Deborah Laufer has filed more than 600 separate lawsuits, most of which appear to follow the same pattern. According to a federal court in Maryland, the defendants are mostly small hotels, which Laufer accuses of failing comply with a federal regulation that requires them to disclose on their websites whether their rooms are accessible to people with disabilities. He also has a notable passion for hiring ethically challenging lawyers. First, Tristan Gillespie was suspended from the bar of the same Maryland court, largely because of a scheme in which he would use Laufer's cases to extract money from these hotels for work he never did. Another, Thomas Bacon, was Gillespie's boss and mastermind of the scheme, which raised serious ethical concerns. According to court, another former attorney, Daniel Ruggiero, was banned from practicing law for a year over an unrelated scheme targeting homeowners with unpaid mortgage bills. Aitchison Hotels v. One of Laufer's many cases is now before the Supreme Court. It seems like the kind of horror story business lobbyists are telling lawmakers to sell them on. Tort reform. It involves perennial plaintiff and lawyers who appear to have benefited from a scheme to shake down small business owners, at least one of whom, Gillespie, is the subject of blistering federal court opinion that disciplined him for unethical behavior. But there are some pretty high stakes behind the ridiculous underlying facts of the case. It involves testers, civil rights plaintiffs who volunteer to confront discrimination so someone can challenge a discriminatory business behavior in court. There are very good reasons why Laufer, whose many cases are more than pushing the limits of the federal court's jurisdiction, should not be allowed to bring these cases. But in a worst-case scenario for civil rights advocates, a Supreme Court dominated by conservative Republicans might not just shut down Laufer's broad range of cases. They can also cause great harm to civil liberties on a large scale. Beyond fact that the current crop of justices frequently change law to benefit conservative causes, it is difficult to assess how likely this outcome is. But there is at least a real risk that so many the justices, so enraged by Laufer's case mix and the behavior of some his lawyers, issued a very sweeping decision that eliminated many valuable challenges to discrimination. Testers, briefly explained Havens Realty v. In Coleman, the Supreme Court considered a fairly ordinary case involving tester plaintiffs. These testers are often the best, or even the only, way to drink discrimination that would otherwise go undetected or unconfirmed. Even if suspect discrimination, they are unlikely to be able to prove it unless know about family of a different race who received different response from the same landlord. And even if are sure they were turned away illegally, may not be willing to pursue an attorney and file a lawsuit. Laufer claims he is no D.